speak
to
the
point taken as to what the history is, but still, I mean, we don't go around just creating independent agencies. More often we destroy independent agencies.
That seems to be.
You know, the idea that we would take a statute which doesn't set up an independent agency and declare it one strikes me as pretty inconsistent with everything that we've done in this area.
In terms of construing statutes to maximize presidential influence over the
yeah,
over
I
the
mean that
independent
you know we've basically said we're not going to read something as putting restrictions on removal power unless it puts restrictions on removal power.
Right, but the problem here, it's not really a question of removal power, Justice Kagan. The test for principal officer status turns on whether the Secretary can direct and supervise the decisions of these task force members. It's the question whether the
Well, why isn't removal power enough? Suppose that there were clear at-will removal power here. I mean, we've gone to such lengths to say that that's pretty much, somebody said it's not the end-all and the be-all. I think Mr. Mupan said that. And I don't know if you read this court's decisions, it seems often to be the end-all and the be-all, that the court has suggested on many occasions that removal power is really the essence of control. If you have it, you have control. If you don't have it, you don't have control. Now, as you know, I'm sure, on a number of occasions, I've said that that understanding of removal power is not realistic, at least in certain contexts. But the court has said it again and again. So why doesn't it get you, if not 100% of the way there in a context like this, pretty near there?
I think that argument would have more force if it weren't for the opinion in Arthrex. And if we were litigating this case 10 years ago before the Arthrex opinion, I think that would have that would be a very powerful reason to say these could be inferior officers. But if you look at the Arthrex opinion, pages 15 and 16, where Arthrex catalogs all the ways in which the PTO director can influence the decision-making of these administrative patent judges in an informal way, without the formal ability to review their decisions. And then the court says, not only is that not good enough, it actually says that aggravates the problem. This is not the solution, it is the problem, because it blurs the lines of accountability and it undermines the transparency that the Appointments Clause is supposed to provide. Again, if Arthrex wasn't there, I think we could have an interesting discussion about whether the test for principal officer status should be this formalistic test that Arthrex sets forth, or whether we should have more of a hard-nosed legal realist look at the actual powers that the Secretary can exert to influence the task force. But Arthrex really, I think, makes it hard for that argument to get off the ground.